So thank you very much, everybody, for joining us. My name's Melissa Dixon. I'm here with Stephanie Duggan from the Public Trustee and Natalie Sylvester from the Queensland Law Society. I'd like to begin by acknowledging the traditional custodians on the land on which we gather today, and I pay my respects to their elders, past, present and emerging. And I extend that respect to Aboriginal and Torres Strait Islander people joining us in today's session. It's really great to have your company, and over the course of this session, we're hoping to provide you with a high-level overview about the important considerations you need to make when making a will and enduring power of attorney. I think it's important to keep in mind, though, that this session isn't a substitute for legal advice. The purpose of the session is to give you general information so that you know what options are available to your circumstances, and we strongly recommend you seek professional advice for specific information regarding your personal circumstances. Thank you also to everybody who submitted questions ahead of the session. We'll aim to answer as many of these as we can throughout the presentation as well as at the very end. And yeah, let's get the session underway. So, as mentioned, the purpose of this session is to provide information about key considerations when making a will and enduring power of attorney. By the end of this session, we hope to provide you with a better understanding about making a will, making an enduring power of attorney, choosing an executor for your will, and choosing an attorney. Other important matters you need to consider when creating these documents: the importance of reviewing and updating your will and EPA, and how to protect yourself and others from financial abuse. So we sometimes use the term advanced life planning when we're referring to these conversations. That's a term we use to describe the legal documents that you can use to preserve your choices and wishes, and that includes an enduring power of attorney. And Natalie's going to talk to us about that a little later on in the session. And that's when you're no longer able to make financial decisions for yourself due to illness, injury, or cognitive decline. And the other document is a will. And Stephanie's going to talk to us about that today. And that's about providing instructions about your final wishes and the executor that you choose to carry out those wishes on your behalf. I'd now like to hand over to Stephanie Duggan from the Public Trustee to talk us through the processes of making a will and why that's important. Stephanie is a managing lawyer at the Public Trustee of Queensland. She's a solicitor who has practiced in succession law and guardianship and administration for over 20 years. Stephanie specialises in wills and estates and legal matters for persons with legal incapacity, trusts and litigation. She is a recognised practitioner by the Society of Trusts and Estates Practitioners and member of the Queensland Law Society. So, Stephanie, it's over to you to talk to us about wills.
Thanks, Melissa. Hello, everybody. I'll be talking with you about wills. What is a will? Your will is a document that contains your intentions on what you want to happen when you die. It only comes into effect once you die. It is by your will that you give your belongings on your death. Your money, property, and other belongings you own or might be entitled to. And this is known as your estate. By your will, you choose who you would like to have as your executor. That is the person who takes care of your estate. You decide who you would like to give your estate to, and you make those gifts in your will. A person or an organisation or a charity who receives a gift in your will is called a beneficiary. You might also make some wishes in your will about your funeral. If you are a parent or a guardian of a child, you might appoint a guardian for that child by your will. Why is a will important? A will is important because you decide who you would like to give your estate to when you die. It's your choice. Your will gives certainty about your wishes. Your will lets you plan ahead to benefit those in your life you care about. You can make a new will if your circumstances change or you change your intentions. Some people think, I don't really have anything. Why should I make a will? Again, whatever you have, it is your choice who receives what you own when you die. Some people think, I'm young, I've got plenty of time. Why should I make a will? And it's so that you can plan for the future and those you care about. If you die without a will, it is called an intestacy. Without a will, your estate will be divided up according to the rules of intestacy under the Succession Act in Queensland. That's the law. The law says who gets your estate on intestacy depending on your circumstances. For example, without a will, if you have a spouse and no children, then your spouse will receive your whole estate. If you have a spouse and 2 children, then your spouse receives the first $150,000 of your estate, all household chattels, and 1/3 of the rest. If you have no spouse and you have children, then your children share your estate equally. Dying intestate could cause difficulties for your family, particularly if you have a partner and young children. If a person has no spouse, children, or grandchildren, their estate might then pass to their parents, then brothers and sisters, nieces and nephews, then grandparents, then uncles and aunts, then cousins, then the state of Queensland. Stepchildren and step-parents don't receive anything on intestacy. No friends or charities receive anything on intestacy either. So, this can mean your family and friends may not be provided for in a way that you wish, and it may take more time to deal with your estate on intestacy. The best way to take care of that situation is to make a will. It's important that when making your will, it's done properly. Please see your solicitor for advice and help with making your will. You can find a solicitor by going onto the Queensland Law Society website. You can also visit the public trustee or other trustee companies for help with making your will. Having professional advice and help is important because your will must be properly signed and witnessed to be valid. It also needs to be properly worded to give effect to your intentions. The words used in it need to be clear as to what you mean. If your will has problems, it will need to be dealt with by the Supreme Court once you die, which can take time, cost money, and be stressful. So, it is best that you do not make your will at home by yourself. Instead, get the help of a solicitor, the public trustee, or a trustee company when making your will. Making a will is your opportunity to appoint who you want to be the executor of your estate. Your executor will be responsible for administering your estate. That is an important role, so it's recommended that you choose someone who you trust and will do a good job. Your executor will take care of many things for you, such as making sure your funeral arrangements are sorted, making sure, applying for a grant of probate if that's necessary, getting in the assets of your estate, dealing with your bank, service providers, and all organisations you have accounts with, dealing with your liabilities and any claims, dealing with your property, making sure all your belongings are sorted, finalising any tax, and distributing your estate to your beneficiaries. Again, choose as your executor someone you trust to be responsible. When you go to make a will, the solicitor or person you are seeing will ask you a lot of questions about yourself and your circumstances and your assets and what your instructions are for your will. You will also, in that conversation, be given some advice. Once you've given your instructions and the will is prepared, you will need to read it closely and make sure that it is what you want. You'll see in a will the appointment of an executor, the revocation or cancelling of earlier wills, and gifts to beneficiaries. A will might also contain funeral wishes and some specific powers for the executor, such as selling or dealing with property. And if a person has a young child, they might by their will appoint a guardian for the child. Making a will is about who you want to give your estate to. The gifts you intend to make are entirely up to you. Consider who in your life you might provide for. Who do you have a responsibility to consider? Who do you want to benefit? Make sure you have an understanding of your assets. You can give what you own or are entitled to at the time of your death. Consider how you might give all of your estate. Do you want to give a sum of money or a particular belonging? Consider if you want to create a trust in your will for a person to help them in an ongoing way. Consider a gift to charity. Giving to a charity is a real option as it makes a positive difference in people's lives and can help many causes. Another consideration is your pet. Do you have an animal you love that will need looking after? If so, you can consider a gift in your will to a person or a charity to look after your pet. Can there be a dispute about a will? Yes. At times, there can be issues and there can be a dispute. There are different reasons this can arise, and I'll talk about some. The validity of the will could be in dispute. For example, an issue can arise if there is a concern that the person who made the will did not have testamentary capacity at the time. It might be alleged, for example, the person had dementia to such an extent that they did not have capacity to make the will. That kind of matter is dealt with by the Supreme Court. Another issue could be the interpretation of the words in the will. There might be confusion or a dispute about what the person who has died intended by the words used in their will and how that might affect a gift or who is to receive it. If it can't be resolved, the Supreme Court will deal with that kind of matter. Sometimes an issue is whether a document was intended by the person who died to be their will. Those issues mostly arise when someone makes a document at home without help from anyone else, usually also where the document is not signed or has not been witnessed. The Supreme Court deals with that kind of matter and makes a determination about whether that document was the last will. The most common kind of challenge to a will is called a family provision application. Under the law in Queensland, if an eligible person considers they have not been adequately provided for in the will for their proper maintenance and support, they might bring this kind of application in the District Court or the Supreme Court to seek some provision from the estate. A person who is eligible to do that is a spouse, married, de facto or civil partner, a child, a stepchild, or a dependent. For all of those reasons, it is recommended that when you make your will, you see a solicitor or the public trustee or a trustee company for assistance. I'd now like to hand over to my very good colleague, Natalie Sylvester, who is an accredited specialist in succession law and a member of the Queensland Law Society's Succession Law Policy Committee, who will talk with us about the importance of having an enduring power of attorney. Natalie has completed a Master of Laws, Applied Law, majoring in wills and estates. She is also a recognised Trusts and Estates practitioner by the Society of Trusts and Estates Practitioners, known as STEP, and a committee member of the STEP Queensland branch. Natalie has worked in the legal industry for over 20 years, and since her admission in 2012, has practiced solely in succession law. She is a specialist in all aspects of succession law, including estate planning, estate administration, and contentious and non-contentious estate litigation. Over to you, Natalie.
Thank you, Stephanie, and thanks everyone for joining us today. So I'm going to be talking about enduring powers of attorney. So what is an enduring power of attorney? An enduring power of attorney is a document that contains your intentions in the event that you're unable to make decisions about yourself. And that generally occurs when you experience a loss of capacity. And a loss of capacity can occur either on a temporary basis or a permanent basis through illness, disability, or injury. By your enduring power of attorney, you get to choose who you want to be your attorney to make those important decisions. You also get to decide whether you want your attorney to be able to make decisions about your financial matters, personal and health matters, or both financial and personal and health matters. And that's generally the most common that I see clients elect, is that it's for both financial and personal and health matters. By your enduring power of attorney, you can set terms, conditions, or restrictions on your attorney's power. And it is here that you would provide, for instance, for any pets that you might have and what is to happen to your pets in the event that you have a loss of capacity. In the enduring power of attorney, you get to decide for financial matters when that power begins. It can commence immediately or on a certain event, such as you losing capacity. The power for personal and health decisions only begins once you've lost capacity. In your enduring power of attorney, if you've appointed more than one attorney, you can set out how your attorneys will act. So you can have 2 or more attorneys that act jointly, and that means that they need to make their decisions together. You can have attorneys that act severally, and that means you're appointing more than 2, but any of them can go off and make a decision for you without the other. If you're appointing more than 3 attorneys or 3 or more attorneys, you can have the power to then be by way of a majority, so that at least 2 have to be together to make a decision. And you can also have what's called as successive or successively appoint attorneys, and that is where attorney A acts, and only in the event that attorney A cannot act will attorney B come on board and start acting as your attorney? So who should you appoint as your attorney? Your attorney has to be someone that you have the utmost trust in. And I can't stress that enough. That is so, so critical. You have to have that trust in them. And the reason for that is that there is a potential for your attorney to abuse the power that you've given them. Your attorney can be a trusted relative, a friend, a professional advisor, such as your solicitor or accountant. It can be an organisation, such as the public trustee, public guardian, or private trustee company. In addition, your attorney has to be over 18 years of age. They must have capacity themselves. They cannot be a service provider for residential service if you're a resident there. For any financial matters, if you're appointing your attorney for financial matters, they cannot be bankrupt. And they also cannot be your paid carer or healthcare provider. So why do you need an enduring power of attorney? If you lose capacity, then decisions still need to be made for you. These include paying your bills, managing your property, lodging your tax returns, deciding where you live, and deciding what health treatment you might receive. Appointing an attorney now gives you the peace of mind that the right person that you have chosen will make those decisions for you and that those decisions will be made in your best interests. There are a number of risks of not having an enduring power of attorney. So if you have not appointed an attorney and you become incapable of managing your own affairs, then the Queensland Civil and Administrative Tribunal, which is known as QCAT for short, can appoint a financial administrator and a guardian for you. Whilst the person that they appoint will have your best interest in mind, they might not know what your wishes and needs are, as they might not have had the opportunity to discuss this with them before you've lost capacity. In addition, it can take many months for a hearing and to occur in QCAT. In the meantime, you might be stuck in hospital, unable to be admitted to an aged care facility or receive care in your home, or have your bills paid, because there's no one who's got the authority to make those decisions and to access your bank accounts. The person appointed by QCAT might not have been the person that you would have chosen for yourself. There can also be disputes. If your family member who's applied to QCAT is deemed to be unsuitable, then QCAT might not appoint them. And that can happen for a number of reasons. There could be disputes between your family members over who should be your financial administrator and your guardian. And sometimes QCAT, when they can't resolve that dispute, they will appoint the public trustee to be your financial administrator and the public guardian to be your guardian. There's another document that I wanted to talk to you about today, and that is an Advance Health Directive. So what is an Advance Health Directive? It is another legal document, and it's designed to complement your enduring power of attorney. It's not a document in substitution of your enduring power of attorney. And it allows you to set out your decisions about what future healthcare you would like to receive in the event that you lose capacity in the future. So the importance of having an enduring power of attorney. An enduring power of attorney might be beneficial for you if you have very specific wishes about your future healthcare treatment. And this could be because of your own beliefs. You could have cultural beliefs about what healthcare you might want to receive, or also religious beliefs. It will also potentially allow for avoiding a dispute amongst family members who have differences of opinion over the medical treatment that you are to receive. If family members are disputing, then that could affect you negatively because no decision might be able to be made. But with an Advance Health Directive, you set out exactly what you would like to happen. You nominate specifically what medical treatment you do and you do not wish to have. Your attorney under an enduring power of attorney cannot override the decisions that you've made in an Advance Health Directive, and that's really important to note. To make a valid Advance Health Directive, You need to seek advice from a solicitor or your professional advisor as to whether it is the right document for your circumstances. In addition, you need to take the document to your medical practitioner, your doctor, to allow your doctor to go through the medical terminology with you. It is very heavily weighted in medical terminology, so it's a really critical step. Your doctor will go through the documents, and it's a tick box type of document, and complete the medical side of things. And that's where you set out what medical treatment you do and you do not wish to receive. Once you've done that process with your doctor and your doctor signed off on a certificate that's contained within the document, you then need to take the document back to your solicitor or a Justice of the Peace or Commissioner for Declarations to have it witnessed properly. And only once you've done all of those steps do you have a valid Advance Health Directive. So the other thing that I wanted to talk to you about today was some other important considerations when you are doing a will and an enduring power of attorney, because those two documents are only the start of completing your estate plan. There are other things that you need to consider. And those things that you might need to consider are things like your superannuation. Who is it paid to? It does not automatically go to your estate to be distributed in accordance with your will and your beneficiaries. And that is because this trustee of your superannuation fund might have the power to decide who out of your dependents receives your superannuation if you have not completed a binding nomination. So that's a really important thing to do, is to consider where your superannuation goes and whether you might need to do a binding nomination to ensure it goes where you would like it to go. You might have life insurance. If that life insurance is incorporated into your superannuation policy, then it will be paid to wherever your superannuation proceeds are paid from. If your life insurance is held outside of your superannuation policy, then you'll need to seek advice about where it's paid, and there might be a nomination form that you might need to complete to ensure that the proceeds of that life insurance are paid in accordance with your wishes. If you have an interest in a business, a partnership, a private company, or a trust, then you'll need to consider the succession plan of these separate entities to ensure that any benefits are given in accordance with your wishes. The other thing that you will need to consider is your digital assets. It is a challenging and complex environment. It's always constantly changing because of the digital world. But have you considered what happens with the photographs that you have stored up in the cloud, your iTunes accounts, your emails, and who has access to those emails and can get access to those emails, or any Bitcoin or other cryptocurrency that you might own? So when you're seeking advice on your will and enduring power of attorney, please raise these matters with your solicitor or professional advisor so that you can receive specific advice as to how those additional matters might need to be taken into account for your circumstances. I'm going to hand you back over to Stephanie now, as she is going to talk to you about safe storage of your important documents.
Thanks, Natalie. It's very important to store your original will and original enduring power of attorney and your original Advance Health Directive safely. If these original documents can't be found when needed, it could cause delay, stress, and expense. Your solicitor, the public trustee, or other trustee companies or your bank can store your original will and enduring power of attorney documents safely. You can store a copy of your enduring power of attorney and your Advance Health Directive with the statewide Office of Advanced Care Planning, which is a free service provided by Queensland Health. They can receive, review, and upload a copy of your advanced care planning documents to the Queensland Health electronic hospital record so that clinicians looking after you can refer to them. Their website is mycaremychoices.com.au. You can give a copy of your Advance Health Directive to your GP and you can upload it to the My Health Record website, which is on myhealthrecord.gov.au. Importantly, tell your executor where your original will is, and tell your attorney and those close to you where your original enduring power of attorney document is stored. It is also a good idea to give a certified copy of your enduring power of attorney document to your attorney in case they need it in order to help you. Over to you, Natalie.
It's really important that you ensure that the plans you have put in place remain current and updated. This generally means that you will need to review your documents on a regular basis to ensure that they do remain current and updated. There are important changes in your personal life that could trigger or prompt you to check your documents. And that could include if you've started a new de facto relationship or ended a de facto relationship, if you've married or divorced or separated from your husband or wife, if you've entered or ended a civil partnership, if you've had a new child, stepchild that's come into the family, grandchild, or another type of dependent, then that's also another trigger or prompt for you to review your documents. If an executor or beneficiary has passed away, that's again another trigger. If any of your beneficiaries or executors have relocated overseas, or if a child or dependent acquires a severe illness or disability, again, there's ways that you could possibly provide for them in a more meaningful way than perhaps maybe what you might have already provided for them. Other things that might prompt a review are changes in your estate. So that could include changes in your assets. Perhaps you've bought or sold property, and property doesn't mean just houses. It could mean shares, and you might have changed your bank account. If you've owned joint assets that have become solely all yours, or you've had sole assets that you've transferred into joint names, then that might be a trigger for you to check your documents. You could have a change in your financial circumstances, such as you might have received an inheritance or some other type of windfall. And if you've started or ended a business, and that could include a normal business, like a sole trader business, it could include a private company, a trust, or a partnership, then it's important to consider the succession plan of those entities.
We see instances, unfortunately, of where people have been financially abused, resulting in loss to them of their money or their property. There are steps you can take to make sure you are protected. Have an enduring power of attorney in place for when you might need it, and appoint somebody you trust and who is responsible. Have a professional assist you with making your will and your enduring power of attorney. Never give your PIN or password to anyone. Never sign any document that you do not want to. Never give a third party access to your bank account. Always seek professional advice when you're deciding to do something that might affect your assets or finances. And importantly, ask for help. You could contact your solicitor, your accountant, your doctor, the Elder Abuse Helpline, the Office of the Public Guardian, the Public Trustee, other trustee companies. There will be always someone who will be able to help.
Okay, thank you so much, ladies. That was really informative. And I know we covered a lot of ground in this session. So I hope that for those who are listening, you are taking away some good things to think about when considering these, and really encourage you to have conversations with your loved ones as well, to encourage them to think about these matters. We get to the fun point now, which is the question and answers section, and we had quite a few questions coming through in all three of our sessions. So this is the fun part where we get to put Stephanie and Natalie on the spot. I might start with you first, Natalie. We had a question about how do I change an enduring power of attorney?
You can change your enduring power of attorney if you have capacity. First, you need to complete a revocation of an enduring power of attorney document to revoke the enduring power of attorney that you are wanting to change. Then you need to prepare a new enduring power of attorney to record your new wishes, such as appointing a new attorney. When you make a new enduring power of attorney, it can automatically revoke an earlier one to the extent of any inconsistency. But you must take reasonable steps to notify your former attorney of the revocation. And if your previous enduring power of attorney has been registered at the titles office, then you need to register the revocation at the titles office as well. And in regards to registration at the titles office, it is only required if your attorney needs to sign a document that needs to be registered at the land titles office. And that usually includes if you've lost capacity and your attorney has to sell your house and sign a transfer. So that's the only reason you need to register it, is if your attorney needs to sign a land titles office document. In relation to changing your enduring power of attorney, it is important to remember some circumstances in people's lives affect the validity or operation of an enduring power of attorney. For instance, if you marry or enter into a civil partnership after you've made an enduring power of attorney, the enduring power of attorney is revoked to the extent it gives power to someone else other than your husband, wife, or civil partner. And similarly, if you divorce or terminate a civil partnership after you've made an enduring power of attorney, the enduring power of attorney is revoked to the extent it gives power to your previous spouse or previous civil partner. But there's a little bit of a gap there in relation to divorce, because you need to be separated for 1 year and 1 day before you can get a divorce. And so you might have separated from your husband or wife, but not have, but be waiting out the 1 year and 1 day before you can get a divorce. And if your enduring power of attorney that appoints your spouse is still valid for that period of time, unless you revoke it and have made a new one. So it's really critical in that period of time, because most people don't want their separated partner to be making those decisions if they were to have lost capacity. And so that's a really critical time frame to update the documents where there's not an automatic revocation. But the important thing is to get some professional assistance. If there's any change in your circumstances in any way, seek some advice about whether that affects your documents, the validity of your documents, and what changes you might need to make.
That's really interesting. I just assumed that if you created a new document, it would override the old one, but that's not necessarily the case. So that's a really good distinction to make. Thank you for that. Another one along similar lines, over to you, Stephanie, for this one. What happens if you nominate someone and they sign all the paperwork, but when the time comes, they find it too difficult to take on the role? Can the nominated person, being your attorney, nominate someone else to carry out that work?
Well, I'll answer this question in relation to enduring powers of attorney and also wills. So in relation to your attorney, to complete your enduring power of attorney document, your attorney needs to accept the power given to them. And they do that by signing the enduring power of attorney. If you have capacity and your attorney decides that they no longer want to be your attorney, They can resign from that position by giving you written notice of their resignation as your attorney. If you receive such notice, again, when you have capacity, then you will need to review your enduring power of attorney and obtain professional advice on making a new one. If you do not have capacity, if you've lost capacity, your attorney is unable to simply resign and must apply to the Civil and Administrative Tribunal, QCAT, for leave to resign as your attorney. It will then be QCAT's role to appoint a replacement guardian or administrator. That is, of course, if you do not have any other attorney appointed. If your attorney can't do it because they've died or they themselves have lost capacity, then if you do not have another attorney appointed, QCAT can decide whether to appoint a guardian or administrator for you. You can appoint a successive attorney in your enduring power of attorney, as Natalie said earlier. They will only have the power to act when your original attorney's appointment ends. You could also specify circumstances on when their power will begin. Again, get some professional assistance when preparing your enduring power of attorney. In relation to your executor, once you die, your executor can renounce from that role before they take substantive steps in administering your estate. If you have appointed a joint executor, the remaining executor can continue to administer your estate. If you have appointed a successive or substitute executor, and that is someone who you nominate in your will to act when your first named executor is unable to, then that person may be able to act if there's appropriate wording in your will. If you have not appointed a joint executor or a substitute executor, and then there's no executor willing and able to administer your estate, in this circumstance, the law in Queensland sets out who has priority to apply to the Supreme Court to administer your estate with the will. If you have a relatively simple estate, then it's normally the residuary beneficiaries who will be able to apply to the court to become the administrator of your estate. However, if there's a conflict between your beneficiaries, then this could present some complications and delay your estate administration. So it is ideal to nominate a substitute executor and ensure the wording in your will is properly done in case the first named executor is unable to act.
That's really great information, and I think it really points to the need when you're asking someone to be your attorney or your administrator for your will to really help them to understand what that might mean. I know personally recently I was asked to be an attorney in an enduring power of attorney, and the conversation was just, can I nominate you? Is that okay? And I think it's really easy for us to do that, isn't it? Just ask someone, but they might not understand fully what they're signing up for. Would you agree with that, Stephanie?
I guess so, and I think that's the importance of people learning about enduring powers of attorney and wills.
Yeah, no, it's really great. Now, one more question. We've got a couple more actually, but this time over to you, Natalie. We've had the question, why do young parents need to make a will?
There's a number of important reasons parents, whether they're young parents or maybe slightly older parents, need to make a will. Firstly, if you're a parent with children under 18, then it's important to appoint a guardian for your children, and that's done within your will, and this is known as a testamentary guardian. The appointment of a testamentary guardian only takes effect once either you've died and your will specifies that the appointment of the testamentary guardian takes effect on your death, or otherwise it takes effect when the surviving parent of the child has also died. The testamentary guardian will be able to make important decisions for your children that you normally make for them as their parent. A testamentary guardian would only have daily care authority for the child if there was not another surviving parent or another person already appointed for the daily care under an order of a federal or state court. Some people think that their child's godparents or grandparents automatically obtain daily care and guardianship of the children, but this is not correct. If you do not have a testamentary guardian appointed in your will and there is no surviving parent or court order already in place, then it is possible a court may decide who becomes the legal guardian of your children. If there's dispute between family members, then this dispute could have a negative impact on your children when they are already grieving the loss of their parents. Providing them with stability at this time is fundamentally important, so it is really important to appoint a testamentary guardian for that reason. Secondly, your will should nominate an executor and trustee, who is the person who would hold your children's inheritance on trust until they reach the age that you have set out for them to receive their inheritance. Under the intestacy laws, and the minimum age that they can receive their inheritance is 18 years of age. However, many parents that I come across believe that that's too young for such a large inheritance, and it's usually increased to either 21 or 25, and you can only do that within your will. And the hope of increasing it is that by the time they reach 21 or 25, that they're a little bit more mature and they'll spend it a little bit more wisely. So that's another reason to make a will. And you have a choice about who will hold your children's inheritance on trust for them. And they have the ability to make distributions when needed to their guardian until your child is old enough to receive those funds outright. Thirdly, if you have a will, you can enhance the executor and trustee's power to give money from the trust fund for the children that's held for the children to their guardian for their maintenance and support. Wills drafted by professional advisors usually contain a power to the executor to release funds as they see fit. And this can be particularly beneficial to ensure your children do not miss out on opportunities in their lifetime and that their guardian is not financially disadvantaged in looking after your children. Finally, if a parent dies without a will, then their estate is distributed in accordance with the intestacy laws that Stephanie mentioned earlier. As Stephanie mentioned, if you have a spouse and children, then your estate does not go wholly to your spouse. Your spouse gets the first $150,000 plus household chattels, plus either half or 1/3 of the balance, depending on how many children that you have. This can present challenges, particularly for the surviving spouse. The best thing that you can do if you have young children is to get some advice and help when making your will to ensure that what you intend is what actually happens.
It's really interesting, isn't it, that your children may be anticipating that someone's going to look after them, a particular favourite relative or godparent. And if you don't articulate that in your will, that wouldn't be the case. So there'd be a lot of trauma on your children potentially if they go to someone else. It's really interesting also to note that we've done some market research in Queensland, and a lot of young families don't have these things in place, and it's just a matter of they haven't gotten around to it. So hopefully if you're listening today and you know people who are in this situation, I think it's really worth considering the potential impact and issues. Another question over to you, Stephanie, we've had is about someone who has 2 adult children with an intellectual disability. And their question is, how do they go about making them a will?
For someone to make a will, they need to have what's called testamentary capacity. The person has to appreciate that they're embarking on the task of making a will. They have to have a general understanding of the nature and extent of the assets which they're going to give by their will. They have to appreciate who might have a claim on their estate and the nature of the claims of those persons. They also have to have the ability to evaluate and discriminate between the strengths of claims of those persons. Part of that consideration is whether a person has a condition that affects their cognition, intelligence, thought processes, judgment, and the like. So what I just said about testamentary capacity applies to everybody who makes a will. If the person who has an intellectual disability wants to, they can be supported in making an appointment to see a professional in making a will. The professional might be able to come to their home if that's more accessible. The professional will talk with them to ascertain their capacity and see if they are able to give instructions to make a will. If they are able to themselves give proper instructions, then a will might be able to be made. If the person does not have testamentary capacity and the intestacy laws are insufficient for their circumstances, it's possible for someone, say a family member or another appropriate person, to make an application to the Supreme Court for what is known as a statutory will or a court-authorised will, it's also known as. This is a special will that the court can approve for people who do not have testamentary capacity. It's important for that family member to seek legal advice from a solicitor who has experience with statutory will applications. Have a look on the Queensland Law Society website for solicitors who practice in succession law. There are solicitors listed on the Queensland Law Society's website who are accredited specialists in succession law.
Thank you for that. That's, again, really good information, and something we've been getting a lot of questions about in this webinar series is about people with disability and how they can make these documents. So that's really good feedback from you, Stephanie. Thank you. One last question, and again, one we get asked a lot, is what the costs are with, you know, either making an enduring power of attorney or making a will. Natalie, in regards to the cost of making a will, how much?
There are different options for professional services that you can use in making a will. So you can go to your solicitor, the public trustee, or trustee company. If you're going to a solicitor, each law firm or solicitors will charge differently. Some firms charge hourly rates and some will charge a fixed fee. Some will charge a fixed fee, but then charge more if the will is not really simple. You can speak to a number of solicitors to obtain fees or a quote for doing your will and enduring power of attorney, but the cheapest doesn't necessarily mean that it is the best one for you. You need to consider what is included in that fee. Do they include preparing your enduring power of attorney or providing advice regarding your superannuation fund? Will they help you complete your superannuation fund nomination form? If the fees don't include these additional matters, then you'll need to consider the additional costs of undertaking these steps. Some people's affairs are more complex and will require more advice and potentially other types of documents to be prepared. For instance, if you have a blended family and you're wanting to exclude a child or dependent from your will, or you have an interest in a business, private company, a trust, partnership, or if you have a self-managed superannuation fund, then your affairs are likely to be complex and therefore your estate planning will likely be more expensive. So the important thing is to get some quotes and compare those fees and what's included, so you have an idea of what you're likely to be charged. The other thing to note is that if your legal fees for your matter will be over $1,500, then your lawyer must provide you with written disclosure on what legal work that they will be undertaking, how they will be charging for that work, for example, whether they're going to be charging hourly rates or a fixed fee, and they need to provide you with an estimate of your legal costs.
That's great. I think if we're learning anything today, it's that there's no one size fits all. And interestingly, earlier in the webinar, we talked about considerations. And I think those considerations are things to think about before you do that shopping around. So, you know, you get a quote for most things when you're repairing your house or, you know, getting something fixed. So why not do the same? We will provide links to the Queensland Law Society website so that people can do that. And I think it's important. If I've learned one thing from this series, it's think of the other things, such as your superannuation and other things that you might have that you need to consider beforehand, so you can really go in and ask the right questions. That was the last question for today. Thank you so much, everybody, for being part of today's session, and especially to Stephanie Duggan from the Public Trustees Customer Legal Services team and Natalie Sylvester from the Queensland Law Society's Succession Law Committee. We are extremely grateful to you both for all the time and energy that you've put into this webinar series. So thank you very, very much.